Welcome back. I hope you took some delight in the commentary and at least got the outline of the main issues that we want to touch on tonight. Let me start off by saying what we are not going to do. We are not going to be discussing the verdict of the Supreme Court. We all believe that the court has spoken and we must let sleeping dogs lie. But more importantly, 3 years from now, we shall be holding another election. And the most important thing I think we should focus our minds on is how do we ensure that we can avoid wasting another 9 months of lameness in our country. Joining me tonight are the very first guest on Tarzan's Take, Professor Justice VCR AC Crab, our eminent jurist, chairman of the Statute Law Revision Commission, the author of virtually every constitution in Ghana. Welcome, Uncle.
Thank you.
And my next guest is Nana Atto Dadzie. Many of you think of him as the spokesperson for the respondents, but I know Nana Atto Dadzie as the longest-serving chief of staff in Ghana's history. Served as chief of staff for about 15 years and has seen at first hand what happens when there's confusion in our elections. In both 2001 and 2009, he had to preside over transitions that lasted a mere 5 days. Welcome, Nana.
Thank you very much.
Thank you very much. The third guest, as you may have seen advertised, should have been a spokesperson for the petitioners. Unfortunately, the original spokesperson had to leave town, and his replacement was literally banned from appearing on this program. He sent me an email in which he apologizes because his legal team members have banned him. What I can tell you is that I know Nana Addo very well, and he does not approve of this action. But we'll go on. Uncle, on the very first program, I raised the issue about why we needed to have the petition at all. And I remember you were very firm in suggesting that whatever problem had arisen arose because politicians had tampered with what had seemed to be a normal process in which elections could have been held on time and petitions dealt with. Can you just take us over that ground again a little bit?
What I did say, Doc, was that if you look at the Constitution provides that the election of the president should take place 4 months before the incumbent president leaves office. It's in the Constitution. There's no doubt about it. Then the Constitution further provides that before Parliament is dissolved, 30 days before Parliament is dissolved, you can have the parliamentary elections. So under the Constitution, you can have 2 sets of elections: the presidential election and what we call the general election. People refer to it as the parliamentary election, but I believe the Constitution uses the expression general election. Now, I understand, I wasn't here then, but I understand that the first election under the Constitution followed the Constitution, and a president was elected before the parliamentary elections. The consequences was that people felt that if they were held on separate days, the person who wins the presidential election is likely to is likely to influence the general election. So a decision was taken that should have both elections on the same day. And that's why we arrived at 7th December. But as far as the Constitution is concerned, you can hold the presidential elections within 4 months before the president demits office. And you can hold the parliamentary elections 30 days before Parliament comes. Okay. That is what I said. So the decision to hold both elections on the same day is not the making of the Constitution. That was the point I was trying to stress.
Okay. But the general election point you made, the 30 days, is it fixed or not later than 30 days?
They say 30 days before the dissolution of Parliament.
Okay.
You see, in this country, we don't have the formal system in which the Prime Minister could take a hand in the dissolution of Parliament. Under our Constitution, the dissolution is fixed. So we don't even have prorogation of Parliament because we have a dissolution of Parliament. And that's the problem which we have in this country.
Good. Thanks very much. Nana, before we go into, I know I said we wouldn't go back, but I want us to go forward. As you sat in all those 8 months, and then you came to the end of it, what did you see as essentially the iniquities of the regulations and the law, and how could these, in effect, be made better? You know, because you've actually been through the process and in a sense looked at how the laws were applied.
Yes. Well, thank you very much. Thank you to esteemed viewers. Thank you for the opportunity also. I think that in 8 months, you know, I've seen the Constitution activated by a group of people, persons who feel aggrieved. And it's a constitutional right, and I really applaud them for going there instead of being on the streets. Quite a number of people disagree or have very strong views against my position, but I think that it's worthwhile for a nation that we settle issues in court than, you know, by other means. But in the courtroom, I knew that people will be put to the test. Claims and allegations which are made outside will have to be substantiated. And I kept saying it, that allegations can come in basketful, but in the court of law, you have to produce evidence to back it. So the laws applicable, you know, in this Constitution, the, what do you call it, all the relevant electoral documentation and all that. So I was expecting that the petitioners, those who are coming in to challenge the presumed position of the validity of the election, would necessarily, you know, throw in the necessary laws and whatnot. The presumption is that a president or a person who's been validly elected and gazetted is deemed to be president. You know, it's a presumption of fact. So bringing up evidence is always a tough business, but it's not impossible. If you can bring the evidence and, you know, establish it, that is what goes. Indeed, when it comes to the election petition, it is not so much about laws and technicalities and whatnot. You know, you are dealing with what happened at the polling station or polling stations, in fact, you know, as against the established rules and regulations. And that's really the test.
But putting the test against what happened, I mean, did you think, for example, CI 75 was shown to be very deficient?
Yes, I mean, quite clearly. I mean, CI 75 has come under a lot of stress. I don't think we've seen the end of the attack on CI 75 because the Rules of Court Committee that was asked to draft these regulations pertaining to
74 was the Rules of Court one.
I mean,
75 was the Electoral Commission.
Sorry, the 74 basically was the problem. You know, they were to translate the the Constitution, you know, into procedural steps. There were 75. Sorry, 75.
75 was the Electoral Commission one, which was the actual conduct. 74 was the Rules of Court for the petition.
But the challenge, you know, and I'm saying we are not going to see the end of even both, you know, following what has transpired. Quite clearly, the platform on which our electoral processes, go appear to be solid.
Yes.
And I would say that it appears to have stood the test of time for over how many? 5 or 6 elections. Yes. And very, very fair, and always been improving by the day. In fact, the concept of reform is not new. Okay. And I don't think that there will be a reform only because this election was challenged. There would have been a reform. There would have been the need for a reform.
There have always been reforms after the election.
So I think that's a very important point to make.
I will keep going back and forth from our first meet because certain things came up. And I remember in our discussion, there was this issue as to how long a petition should be allowed to run for. You remember the question was, do you curtail or do you allow justice to be... having seen this for 9 months, well, how can we be very practical and pragmatic?
I keep on telling people that courts are passive institutions. If you don't fight and you don't bring a case, the courts have nothing to do. So you are coming to court. And when you are coming to court, you have to come with your evidence and your facts. If we set a time limit, is it going to apply in every case? Because there may be situations where it will take you a longer time to get your evidence. There may be cases where you may get your evidence within a very short time. So what time limit are we going to set? That's the first thing. I think because, for example, in Kenya, they have been able to do it within a very short time. People are trying to think in terms of our also having a short time. I happen to know that after the decision in the Kenya case, evidence turned up, which if had been before the court, might have changed things. So this time limit, I have a problem with that. But I also ask a question. If you're going to have a time limit for election petitions, what about a time limit when you have a land case? Why shouldn't you have a time limit for everything?
That might help everybody.
Exactly.
But I asked that question, and in the context, because earlier on I was talking about the practical issues you had to deal with. Can we say that we're all agreed, I hope, that disputes will be settled ahead of coronation? Or is there a dispute there?
It can be done. If you want that as a process, as I said earlier, you have 4 months within which to hold the elections. Mm-hmm. So if, for example, we amend, and I believe my colleague here last time,
Gabriel Praman said
they did say
they've gone for 60 days.
Yes, they brought in 60 days.
60 days before.
So if we have the election 60 days before that, it should be possible to have the dispute settled before the 7th January. It's possible. It depends, as my colleague said, it depends upon the evidence which you're going to bring before the court when you go to court. It's entirely a matter for the person who goes to court.
But mustn't we insist on that as part of the process? Because I think what at least I've learned from this whole process is that if you swear in a president ahead of a dispute, they're almost a lame duck president for the duration.
Not necessarily. No. The Constitution itself.
I know what the Constitution says.
Yes,
but
presupposes that you could have a challenge which will overrun the period. So there is a provision in the Constitution that if the election is upset, whatever the president had done remains valid. It's in the Constitution.
No, I accept that one, but I think the reality of the last 8 months, everybody has talked about the business slowing down and things not going well. I think from where I sit, and I haven't done any scientific opinion about it, that most people will prefer that disputes are settled ahead of the president being crowned.
Yes, I think that we also must admit that whether it is before or after, the whole process of adjudication takes time. That's the fundamental point, that we must have time. Is this a worthwhile exercise, to go to court? And I've told you that it is better to go to court and get a settled, a civilized way of settling matter than to allow people to use other means. So we should also have that kind of mental, what do you call it, shocks. That, well, there may be disputes and may take time. In Nigeria, in some cases, it took 2 years. You understand? Well, in some countries, yes. In America, as we were saying, I've also studied that bit of it. The election and the coronation, they were about 76 days, actually. And in some cases, it ran up from November to March. These days is largely, you know,
the 20th of January, they must,
exactly.
4th of November to 20th of January,
so it also allows room for, you know, settlement of issues. But I am worried about putting tax on. Just that, of course, in our country, business and politics seem to merge. That's the problem. But if there's a dispute, somebody has a dispute,
they merge everywhere.
Why should it?
You know, well, immediately after Iraq, Halliburton was given an 11 billion contract.
Yes, but even
and you know who was in charge of Halliburton?
Yeah, but even so, you know, it should be possible for us to go on with our adjudication without necessarily stopping. When we look at that, people said, don't even discuss the issues. You get me? Because we are not used to it. So for me, I think that it is also the novel aspect of what we've gone through that has also created a whole lot of hype about it. Otherwise, from where I'm sitting, back to your question, it's a question of evidence. If you have enough evidence, you can tender and put in your evidence within 7 days. The judges have a way of cutting down evidence in such a way that, you know, what you term the court management, they can, you know, give time limits.
Well, you see, this time management what is it? You're talking about, and the period. If you remember, after the election of Mr. Edward Akufo-Addo as the president of this country, Joe Appiah challenged it.
Yes.
We went to court. It's the same process. Yes. But I think within a week it has been
was over.
Because of the evidence that was put before the court.
But I understand what you're saying, but I think if you ask the ordinary person on the trot to Medina, they would prefer a certain order. The order must be, whatever disputes must be settled. Talking about, you don't think that in 4 months we can do this if we set the rules? For example, in Kenya, you must file a petition within 7 days, not our 21 days.
Yes.
What stops us if you have a genuine complaint? What stops us saying that you must file a petition within 7 days?
One has to take into consideration the conditions in your country. Probably it's easier for them in Kenya to gather all the evidence within that period. But as I told you, after the decision had been given, evidence came up, which if it had gone before the court, probably the decision might be different. So perhaps, whilst we here are thinking in terms of having a shorter period, probably they in Kenya might be thinking of having a longer period. So you see, you have to take these things into the circumstances in your own country. Shorter period, longer period, what does it matter if in the end justice is done?
Yes. Let me ask you a very direct question. Are you suggesting that we should retain the status quo and that we shouldn't make sure that there is a certain order that brings sanity? In my view, is a suggestion that we should retain the status quo.
There is sanity already in the system. They went to court. We've gone to court. Yes. And personally, and I've said this openly before, I'm very happy that we had to go to court. You see, you don't have a constitution which is not tested. We've had an opportunity to test the constitution in a very important issue, the election of the president. As I said a little while ago, we did it in '69. We've done it in 2012. We are moving forward. Democracy is not a rock.
No. Justice, I think we're all agreed on the fact that this matter was tested. But going forward, I mean, are we actually saying that the status quo should remain?
I think that what my
in terms of timing,
senior is saying is absolutely right. You see, in this court for 8 months, a lot of time was also spent trying to, build the ground rules. A lot of time was spent disagreeing and all that. Now, because, as I said, it was a novel thing, and we didn't know, well, the judges and the lawyers were, were plowing into fresh grounds, But now we have a precedent. Now everybody knows how to go about it. Even we know how to settle issues. Yeah. I mean, we didn't even know whether we were going by memorandum of issue or whatever at the time. You see, so now the rules are clear. I can understand if it ever happens again. Within a short time, you can ask for 7 notice of petition. You can do that in 2 days. Okay, let me do 7 days. Then
so now that the rules are clear, can we do it quicker?
I think
yes, it will come quicker.
Can be done quicker.
Yes.
Well, I mean, sorry, I keep going back to Kenya because that's my only example that I think I can think of.
What about Uganda? It have a similar thing in Uganda.
I mean, the thing I'm going to go about, for example, they don't like all that constant changing of what was filed.
But well, I'm not too comfortable.
You are the lawyers. I want to know, for example.
No. But I'm not too comfortable with comparisons of such a nature, because Ghana. I'm sorry. I'm sure you know. I'm going to say the same thing. Ghana is a very unique country. From the 8 months, I think that patience, that resilience, that all Ghanaians have shown, it's been really commendable. And we should not compare to that level if I were finished, the level of justice that we were demanding, I mean, that the petition were demanding, all Ghanaians were demanding. Now the judgment comes out, well, everybody, we are not too happy, but what can we do? This is it. I think that in some other countries, like the judge said, in some other countries, it festers after the judgment. People are still not happy. Is that what you want? Ours is freedom and justice, and justice according to law.
My difficulty with your uniqueness is that I have read the whole judgment from, I'm a civilian, you are a lawyer, he's an eminent jurist. What struck me was the several references to Commonwealth jurisprudence in that judgment.
Yes.
And Justice himself has been one of the key teachers of all these things. So when you start talking about uniqueness, and there's a court case that is quoting copiously Commonwealth jurisprudence, I find that difficult to take. Could Justice help me?
I don't see why. I don't see why you have that difficult to take. Because our jurisprudence is based upon the British system of jurisprudence, and all the Commonwealth countries which have been mentioned in the judgments, they have the same basic common law
exactly
form
the point
of jurisprudence.
yes.
And that's why judges all over the Commonwealth look at other decisions in other Commonwealth countries, because we have a basic common law system of jurisprudence. And that's the reason. That's number one. Number two, some of the issues we've been dealing with have also happened in the other countries, based basically almost on the same law. And so if a decision has been taken, you look at the circumstances in your own country, how far that decision in that country could be of assistance to you here, and then you do it. And that's why you have had the references to those situations.
I agree with you entirely, but
I think
was
it's just inspirational. We take inspiration from these. It encourages us that we are within the Committee of Nations, but essentially what we're doing is very unique to us. I mean, it's very special to us. I mean, it's a novel. This is the first real test. I mean, the Kufado's case came up earlier on, but this is a real challenge, where two parties actually pitch their strength, whether they came in real form or not. You get me? There were 4,000 NDC people who swore an affidavit to defend their position. 360 who also, applied to join. They were rejected. You understand? There were mass on both sides. The 5.5 million supporters of John Mahama and another 5.2 million supporters of Ronaldo. So it's a very, very unique
But I'm saying
situation.
that those 11 million supporters, who are people who voted, not supporters, voted one way or the other. My sense is that looking forward, they will prefer a certain order. But we can leave it here for now and develop it later.
We have to appreciate that we are practicing what you call democracy. These are the incidents of democracy, and we're moving on. As my colleague said, we've learned lessons from this one. Next time, it wouldn't be the same, because we will not be making the same mistakes. What are we going to do which is going to be different from what we have done?
Yeah.
In essence, to me, it's going to be very less.
Let's start from there. You talked about these the 30-day requirement for general election. Is that an entrenched provision?
No.
It's not?
No, that's going to be amended.
Okay.
I think the Constitutional Review Commission has recommended it. Government has accepted it. So there's no problem there.
If it's not an entrenched provision, we don't even need the Constitutional Review Commission. Parliament by itself can do that amendment if it so wishes.
You see, but I wasn't feeling comfortable the way you almost just threw it in. You must understand the circumstances under which that clause was almost not activated, because at the time, people didn't have patience for power. You know, in 92, the Constitution was coming in. It's like there was a presumption that, or the assumption that some power must be delivered, and must be delivered now. You see, so, and then there was also the feel that...
But the Constitution didn't actually come into place until 1st of January.
1st January 1993.
Yes, but the election.
Yes.
The
election
election,
the Constitution?
Yes.
I thought the old Representation of the People's Act.
There was the presidential election itself.
Law.
Yeah, the presidential election was 92. The president took office in 93.
In January.
Yeah, in January. So, you see, you must take the heat at the time. One, nobody was prepared to wait, particularly at the time, for a military government, you know, to hang on another 4 months, 3 months. Yes. You know, if we win, no, so it must be now. Secondly, they thought that if we had a presidential election earlier, you know, which at the time, you know, having regard to what the later on came to be said, the lack of equal playing field.
What do you say we thought? You were the chief of staff at the time.
No, I'm saying that I'm in the sense of the people of Ghana. Yeah. I'm being careful here. So, you know, it was written. I mean, the stolen verdict and whatever, there was no level playing field at the time. So whoever had been in power for so many years was more likely to win. But if he won, then it will influence the parliamentary election automatically. Yes. So the situation at the time was that people said, let's have one election, let's have it the same day, and let's have it now.
No, quite.
No, yes. I understand the move, because I was a party to the stolen verdict and all the problems that came out of it. But what I was
that's why he talks about the politicians.
Yes, that's
one of them.
And that was a genuinely stolen verdict.
Okay.
But no, what I wanted to clarify, because I want us to be moving this discussion forward, I wanted, because this is the encyclopedia we have of our constitutions, absolutely. And that's what I wanted to know, whether, if it's not an entrenched provision, then it makes changing it easier.
Oh yes, I don't think there's going to be any problem.
Right. So
when these constitutional changes come, it's where there is controversy that you have a problem. But I don't think over this one there's going to be any controversy. I think everybody will accept it. There wouldn't be any difficulty.
Let me then put it the other way. Is it necessary? Can't Parliament, in the same way, for example, that you are a party to the preparation of the Transition Act and all of that.
Both of us.
Both of us.
Both of you.
Actually,
exactly.
Exactly. Sorry.
There you are.
I needed to correct that. I was part of the transition team.
So there you are. We have the nucleus of the putting together the Corrections Act. Can we say then that the same process that you adopted for the Transition Act, because I have certain reservations about the CRC process, which, in my view, could derail the rapid implementation of the Constitution. But I don't want to get into that here. Could we use the same Transitional Act process? But before I get to that, let me ask you another question. The rules of court process in the Constitution, which the Supreme Court uses to do CI 74, for example. That's also not cast in any
No, that's no problem. All it says is that Article 157, you have the rules of court committee which must do these rules. Okay. They've done the rules. It's being applied.
Yeah.
What have been the deficiencies? Yes. What are the problems? Yes. We'll amend the law and we go forward. Good. We also agreed that there is the need to change the date for the election, for a general election.
That's right.
We agreed on that. There's no problem with that. So we are moving forward.
We're moving forward.
Yes.
No, I just wanted to clarify that the essential provisions that need, in effect, to be tweaked are not entrenched.
No.
So yeah, but if they were entrenched,
there will be no problem.
There's a process for change. It's changeable. We can do that. If, as a people, we think that it will impede our progress, you know.
I understand that, but I've just said already that I have a difficulty with the CRC process, which may come. So if there are processes that have been tried and tested, of which both of you are central characters in it, then we can use the same process. Yes. I'm just trying to give the idea that we can, if we are minded, do something quickly.
It can be done. I mean, I don't know, you've been part of government before. You know that most of our problems, we are not able to achieve them because you don't have the political will. Where there's a political will, we'll achieve it, isn't it?
Yeah, absolutely. Yes. But the building of that, I think that is really an issue of consensus building. I don't know whether I'm jumping the gun, but
no, you're not jumping the gun. We're having a conversation.
Yeah, okay. In the
so
conversation,
you can jump in anytime.
I think that the IPAC, the Inter-Party Advisory Committee, done a wonderful job in the past. Within that forum, they were able to push so many reforms, including this biometric verification and all that. They will have
from photo IDs.
Exactly, the photo. So basically, I think that for me, speaking for myself, I think that what we spent 8 months doing in court, we could have probably used 6 weeks doing at the IPAC. You know, it is okay going to court to test the issue, the essential issue of evidence, yes, but you found out that when you go back into, say, Mr. Justice Doche's judgment, very thin.
I call it the schoolmaster's script.
Yes, he set out so much more on what must be done. Like we talked about a roadmap. You know, well, the training, recruitment, and whatnot. I mean, some of the presiding officers, he described them that they were illiterate. I mean, you can't believe some of the entries they made. You understand? What has that got to do with the rules and regulations? Yeah. It's just that the person,
because some politician use some bureaucrat to decide that teachers will not be allowed to become presiding officers.
Well, there's no evidence. Yeah,
no, it was in the papers. It was announced.
No. It's not all that is in the paper. That is
it was announced by the GES.
But you see, no. But again,
I don't say that's a political point. I'm just saying that we shoot ourselves in the foot with some of the things we do.
Yes, but I think the point is that we must look at our training. We must look at the recruitment processes, the time that we spend on these people, the funding. I think that as a country we must also talk about funding. We talk so much. How much do we put into election? As of 1992, it was like, well, if you want us to go this way, the foreigners, you are talking about all kinds of things. Come and pay for it. You understand? So that
but that's
so
par
much
for the cost.
On the donor, so much on the reality we didn't have money. But the donor thing also must face.
But let me ask Uncle something. You see, because this IPAC thing, there's now the initial and beginning calls are for IPAC must be strengthened. I mean, they haven't used the word almost sort of legalized through law.
But law.
What's your take on that? Because the independence of the Electoral Commission is cast in concrete in the Constitution.
Yes.
And you've got how are you going to make IPAC decisions almost enforceable or have
well,
to
you see, the problem we are having is that sometimes we tend to think that everything has got to be in law. Yeah. It's got to be written. And Britain hasn't got a written constitution.
No constitution, no.
And yet, they have been able to work things out. And I believe part of the development which we should have in this country, if we're going to deal with democracy, is to learn to appreciate that certain things can be done in the absence of law and done very, very properly. If political parties agree on an issue, it can go forward. It becomes part of the conventions which will clothe the spirit of the Constitution. We started by referring to the period for election of the president,
that's right,
and the period for election, for a general election. There was an agreement. If there are problems with the agreement, how do we solve it? We solved that one. We now realize that let's push one back a bit. We have a same date. And that's how we can move forward. The other countries we see and we appreciate, they have gone through these processes. Don't forget, until the Reform Act of 1832, weren't they doing all the silly things which we had
the rotting boroughs and all that?
I was a founding member of IPAC, and I served it for many years. And I'll tell you what some of the problems that come up, very practical problems. First problem, for example, is when must IPAC meet?
Yes.
There is, you know, when shove comes to push, the commission insists that that lies with them. And in fact, many times in the run-up to important elections, the political parties, usually depending on the one which is in opposition, is wanting a kind of regular schedule put into place for IPAC to meet. And it gets pushed back. So issues like when IPAC should meet, what should happen to consensus decisions, how should matters be tabled? Because even though it's a very good consulting process and it's done a lot, the upper hand still lies necessarily with the commission. And how do you put some kind of, shall we say, equity into it?
I haven't been to any of the meetings of IPAC,
yes.
And I don't know what you politicians do. But from listening to what you say, I get the impression that there's a lot of mistrust. And if there is a mistrust, it's very difficult to reach a compromise. I think probably we have reached a stage in our affairs where we should learn to trust each other. I don't see why on such issues, on such fundamental issues, which have something to do with the governance, the lives and welfare of the people in this country, there should be that kind of mistrust. You are saying that when you are in the opposition, you do something. When you
no,
are
I'm
in
not. I'm just saying. I'm saying that the rules of engagement are necessarily in the bosom of the commission, and sometimes clarity and regularity, if it can be introduced, will remove the kind of suspicions you are talking about.
Exactly.
You
Once
know?
we are able to work harmoniously with the Electoral Commission, and we should in the circumstances, because you are the prime actors. The Electoral Commission provides the space, as it were, and you are the prime actors on the stage. So a lot of agreement amongst the political parties, in my view, is relevant to what we are discussing. And if we go along with that process and we agree on certain things.
There's a lot of agreement, but you know, Nana raised an issue, and that issue lies underneath all the tensions that come up. He raised the issue of level playing field.
Yes.
And
Trust.
you know that most of the issues of level playing field are to do with which side of the fence you are standing at the time.
Yes, but...
and I admit that IPAC has done an awful lot. In fact, from the time when there were no pictures, all the stuff that have come from IPAC,
opaque
where we are now,
boxes,
are all to do to IPAC. But I can tell you, for example, in the run-up to the 2012 elections, there was a very serious issue as to when IPAC should start sitting, for example.
Yeah. You see, sometimes the problem with us is that when people do very good things, we don't seem to talk about it. We're always talking about the bad things. And you've just been mentioning how IPAC has done very good things. How often is this in the open for people to appreciate that, look, Politicians have been working together. They've been trying to evolve a system which will make our democracy work. We don't. And these things also should come up for people to realize that it's not always that politicians
I think
are at each
politicians
other's
in
throats.
general recognize that IPAC has done a fantastic job.
But do they make noise about it?
But
Do
do
they
need,
make noise about it?
but
Oh,
do,
yes.
do you need to legalize IPAC?
No, that's the point I'm raising.
I
That
don't
has
think-
come up. And
I
all
don't
I'm
think
doing
it
is
is
that I'm
necessary.
raising issues.
Yes.
The point of the matter is that we've come out of an experience.
Yes.
And one of the things that I think came out of all of this was that we don't have an issue with transparency
No.
in our elections.
No.
No,
I have said
No.
that we probably got the most transparent and all-inclusive process.
Yes.
But we clearly have a problem with the operationalization of the system.
Yes.
So we're all looking at how do we make it better.
If I may just.
And some are saying
Tarzan,
IPAC should have legal teeth. That's the issue I want to raise.
I think that to hold IPAC, here, will not be looking at the issue from the right perspective. What came out from the 8 months, quite clearly, is that we have a system that is deficient from below, you understand? Quite clearly, when you operationalize it, there's a whole lot of problem. Looking at what Atuwa listed in page 48, he talked about the register. There's a need for a supplementary a main register to be issued early, and a supplementary register, if at all, coming in late. Then the caliber of the presiding officer must be greatly raised. He talks about the pink sheet being too elaborate. All this C plus this and whatnot. It was interesting to see lawyers and judges at the court fighting over, talking about whether it should be correct for a dash to be to amount to 0 and all that. You get me? Then the carbon copy system must be improved. The biometric device system must be streamlined to avoid breakdowns. Invalidating wholesale, votes to be, the points of objection came really, that's what I say, is evidentiary. They are about matters of oppression, the quality of the people, the quality of work that they did.
It's all about people.
But the platform that we were using was transparent,
Right.
very solid,
Yeah.
tested. IPAC got everything out of even government or whatever. At the tail end, they were asking for expensive verification machines